I have Michael Crew on the line with me today, and we are talking about a new law passed July the 1st, so within the last couple of weeks, that affects homeowners associations in the state of Georgia. Michael, set it up for us and explain to us what is happening.
And what we're seeing around the country is legislators are starting to dip their toes more and more into regulating homeowners associations, okay, into protecting the association's rights and in protecting homeowners' rights. There was a state law just passed in Florida, just went into effect in Florida. It's got a couple of good provisions in it and some kind of bad ones. Nevada has a law, California is super regulated, and Georgia is taking a really positive approach to working on association governance.
Okay.
Every year they work a little bit on the law. Their decisions are generally well considered. They have a study group that looks at HOA and condominium regulations. They work with the local Georgia chapter of the Community Associations Institute. And so things are moving forward in a pretty positive way in our state. And that's a good thing for all of us that live in HOAs.
That's good. And you, I know you well enough to know you call a spade a spade. So if you thought what they were doing was junk, you'd be saying that.
I would be.
Yes.
You're right. So this year they cleaned up a problem that popped up in the courts. Okay. And this ties right into the issue of what can homeowners do, okay, or what can associations do.
Okay.
In covenants, there's whenever a homeowner an owner violates a covenant, there's provisions to help motivate the homeowner to do what the association wants.
Right.
And for many associations, those motivational factors include things like fining the homeowner,
right,
revoking their right to vote. Big whoop. Most of them don't anyway.
Right.
Okay. Not using the amenities like the pool or the tennis courts or whatever. For a lot of people, that really does matter.
Sure.
So there's different things that associations do. But one problem we've always had is there's a provision in almost every set of covenants that's called self-help. And what it says is the association can physically go fix the violation of their own accord and bill the homeowner back. Okay. Well, the problem with that is you can't walk onto anybody's home property, into their lot, and paint their house. I mean, you can't do it. A, put yourself in danger. B,
right,
no painter in his right mind will sign up for that. And C, if the homeowner calls the sheriff will tell the association to leave.
Right.
Because sheriffs don't interpret covenants.
That's right.
They interpret the state law, and there's a trespass law.
Yep.
Get off the guy's property.
That's right.
So what the association does is they go to court and they ask for injunctive relief. They ask for the court to compel the homeowner to allow the self-help. And there's been a couple of conflicting court decisions about whether or not an association can go into court and get one of these relief petitions, okay, without first trying to do every other thing possible that they could do.
Right.
Fine them, suspend them, send a painter to their house. And as I said, the painter issue is a non-starter.
Right.
So there's a roadblock right there. So the legislature this year proactively stepped up to the plate and said, we're going to fix this in the statutes. We're going to make it so associations can go into court and get injunctive relief without having exhausted all of their prior remedies.
Okay.
So the reason this is important is every board member needs to understand this, because this is like adding a sledgehammer to their toolkit of the ways they can approach things. I mean, it vastly cleans up their problem. And every homeowner needs to understand it, because when I talk to homeowners and they say, well, what are you guys going to do about this? And I say, well, they'll come and paint your house. They laugh. Okay. And now I can say to them, they're going to go into court and get injunctive relief, and a judge is going to tell you, you're going to stand there and watch.
Right.
And you're not going to go up against that, because your solution is a couple of days in the pokey.
Right.
So you're kind of so homeowners need to understand that there's this powerful new solution that's available to boards. So the law that we're talking about is House Bill 220.
Yep.
That's the bill that did this, and they fixed a bunch of other things. So in Georgia, there are condominiums, and they're covered by the Condominium Owners Act. There are homeowners associations, and there's really two kinds. I'm going to call them plain old HOAs. We just call them HOAs.
Yep.
Okay. and there are POAs,
Right.
property owners associations. And the difference between the two of them is in 1994, the legislature created a law called the Property Owners Act. It looked very much like the Condo Act. And it said that any homeowners association that wants to be governed by the Property Owners Act just has to modify their declaration to say, we want to be covered by the Property Owners Act. And it's got a lot of structure in it. It puts some things in statutory rules. It creates some rules to protect homeowners, like how long does the notice for a meeting have to be, and how can assessments be passed, and how does the budget get assigned, and who can get into corporate records. I mean, those statutes have a lot of very pro homeowner items in them. So the legislature included a couple provisions to protect homeowners, and one of them is that in order to get this injunctive relief, they have to provide a 10-day notice to a homeowner. Okay, and they cleaned up the plain old HOA regulations where they didn't have laws that applied to them. There were gaps in the law, and they cleaned all those things up too, so they more closely resemble the condominium in the Property Owners Act. And those are all good things for us, us as owners, all good things for us.